Good evening, everyone. Welcome to the 27th Goff Arbitration Lecture organized by the School of Law of City University of Hong Kong. The Goff Lecture series was inaugurated by City University of Hong Kong in 1990. Lord Goff of Chivalry, then Lord of Appeal, initiated the series. He has been followed by an illustrious list of some of the world's most renowned experts in the field. This year, we are very honored to have the Honorable Chief Justice James Alsop of Federal Court of Australia to deliver the Goff Lecture. From 1981 to 2001, Chief Justice Alsop practiced at the bar in New South Wales and elsewhere in Australia. He was appointed Senior Counsel in New South Wales in 1994 and Queen's Counsel in Western Australia in 1998. From May 2001 to June 2008, he served as a judge of the Federal Court of Australia, undertaking the roles of trial and appellate judge on a full range of federal court work. From June 2006 to February 2013, Chief Justice Alsop was president of the New South Wales Court of Appeal. He was appointed Chief Justice of the Federal Court of Australia as of 1st of March 2013. Over the years, Chief Justice Alsop taught part-time at the University of Sydney and also the University of Queensland. He has also held various other positions over the years. And without further ado, now I'll hand the floor to Chief Justice Alsop.
Thank you, Professor. It's a great honour to speak at a lecture in the name of one of the great judges and scholars England has ever produced. And I thank the university and the organisers for the invitation to speak. Commerce is built on trust. That trust is not in cautious, wishful thinking. It is the requisite degree of trust in the circumstances, usually circumscribed by practical reality, including the mutual advantage of a continuing relationship, a body of information, and a degree of familiarity with the context. Just as commerce is built on the requisite degree of trust, so it is important that the agency of adjudication, which is chosen to resolve disputes that cannot be resolved by mutually agreeable compromise, be able to engender the requisite degree of trust in the parties, including as to honesty and fairness, and most importantly, impartiality. By using the phrase requisite degree of, I'm not intending to water down the important underpinning place of honesty, fairness, impartiality, independence, and trust. What I intend is to recognise that definitions, rules, and moral absolutes have their limitations along with their importance in the real world. Dispute resolution, including adjudication, takes place in the real world with imperfect institutions and humans acting in good faith. The subject of this evening's discussion is the decision of the United Kingdom Supreme Court in late 2020 in Halliburton and Chubb, Bermuda Insurance. It contains important development and clarification of the common law of England on arbitration, recognising and incorporating real-world realities in practice, but holding firm to a demand for the highest level of impartiality in arbitrations governed by English law. It is first necessary to say something of the differences and similarities of judicial adjudication and arbitration to appreciate the existence and content of the legal duty of disclosure of the arbitrator or prospective arbitrator, and the duties of independence and impartiality of the judge and arbitrator. The fundamental underpinning feature of judicial adjudication is the imposition of or subjection of the disputant parties to a form of state power, judicial power. Judicial resolution of a controversy is the state using its compulsory powers to resolve disputes brought to the jurisdiction of its courts by one party. Usually this involves full public disclosure of all issues and an appellate structure of one or possibly two layers. The moving or claiming party in curial adjudication may have a choice of courts, but only within the recognised limits of conflict of laws. For the responding party, the venue is compulsory. Once in the hands of the court, the structure and application of procedure is by reference to the law of the relevant polity. Part of that imposed structure and law will be the institutional choice and imposition of the judge and an accompanying expectation of complete independence and impartiality. The arbitral process of its nature contains within it a degree of choice. Arbitrators of chosen identity and known skill can be provided for, trusted institutions with known and understood rules, and seat courts of known skill can be chosen to supervise the resolution of the dispute. The two concepts of independence and impartiality are not easily disentangled by verbal formula. It is doubtful whether the attempt to define them separately is worthwhile, other than by a recognition of their core meanings. Impartiality is an absence of bias or of partiality to one side or its case. Independence is a lack of control or of influence from relevant external sources. An exploration of circumstances that may lead to one being undermined or compromised generally assists in the consideration of whether the other is as well. The interconnection or relationship between the two concepts is not assisted by definition or seeking exhaustively to set out what may lead to or be seen to lead to an undermining of independence or a compromising of impartiality, although guidelines help. But guidelines often, over time, become seen as rules with defined content, something unhelpful in a context-specific, fact-rich evaluation. It can be said that, ultimately, it is impartiality that matters. That was the view of the English Departmental Advisory Committee on Arbitration Law, leading to the drafting of the Arbitration Act of 1996, and remains the, at least provisional, view of the Law Commission in its current review of that Act. Definition of ethical values, principles and states of affairs underpinning trust and confidence and honesty and fairness risks arid debate and unhelpful distinctions, which likely pay insufficient regard to the importance of context and the necessary indeterminacy of meaning. This is not to promote uncertainty. Rather, it is to recognise the central place of the implicit and the contextual in the application of principles of a behavioural or ethical kind. That is why the conjoined expression independence and impartiality is helpful. The expression may perhaps be seen as, or as similar to, a hendiadys, a figure of speech in which a single complex idea is expressed by two words connected with and, without subordination of one to the other, or without parts of separate and equal standing. The importance of trust and confidence of the members of the polity served by the court and of litigants who come before the court is basal. This leads to the need to express the legal rule by reference to which a judge must decide that he or she cannot be independent or impartial, both by reference to the fact of independence and impartiality and of their appearance externally. The fact of impartiality involves an examination of conscience. That may involve the contemplation of personal circumstance and attitude and an exploration of the possibility of subconscious bias. This requires the expression in words of an evaluative assessment, necessarily by reference to the practical human context in which the question is being posed. Hence the necessary anthropomorphous, that is, of human form, nature of the relevant tests. Trust and confidence are human and emotional conceptions, though linked to rational thought. That thus the test is best expressed and couched in human terms. In English law, the test for apparent bias in decision-making was settled excuse me, in 2002 and 2008 in Porter and McGill and Hello and the Secretary of State. And it is whether a real possibility exists that a decision maker is biased. A real possibility exists where the circumstances would lead to a fair-minded and informed observer to conclude that there was a real possibility that the decision maker was biased. This replaced or modified Lord Goff's expressions, real danger and real likelihood, in the sense explained by his lordship in the eponymous The Queen and Goff, differently spelled, as in terms of possibility, not probability, which had been criticised by the High Court of Australia and not followed in Canada and New Zealand, as being too stringent, overemphasising the court's view and underemphasising the public perception of the circumstances. In Porter and McGill, Lord Hope described as a modest adjustment the introduction of the fair-minded and informed observer that had been used in Australia, Canada, and New Zealand, concluding that there was a real possibility of bias, concluding that there was a real possibility of bias. Given Lord Goff's own explanation in The Queen and Goff, that the court's perspective was the reasonable man observing the perception, and that the perception was one in terms of possibility, not probability, and given the view of Lord Phillips of Worth-Matravers, Master of the Rolls, in re Medicaments, that real danger was the same as real possibility, thereby removing the connotation of immediacy in danger as in clear and present danger. That was a fair comment by Lord Hope, even though his lordship discarded the phrase real danger as not useful. In Australia, the reasonable apprehension test, at least for non-arbitral bias, is whether a fair-minded lay observer might reasonably apprehend that the judge might not bring an impartial mind to the resolution of the question the judge is required to decide. A different formulation applies, however, to arbitration under both the Australian Commonwealth and State and Territory Arbitration Acts. Excuse me, the relevant provisions in those acts give content to Article 12 of the model law, justifiable doubts as to the arbitrator's impartiality or independence, by such being satisfied only if there is a real danger of bias, using Lord Goff's test in The Queen and Goff. This statutory formulation, taken from Goff's case, was advocated strongly by those who saw the need for a higher threshold in adjudicators who were not public officials. Neither the English nor the Australian non-arbitral test require certainty, only a real possibility or reasonable apprehension of bias. These standards support the fundamental principle that justice must be both done and seen to be done. The qualifiers real and reasonable import the notion that the human construct must consider that the potential for bias is material that it logically or experientially arises from the surrounding circumstances for a judge to be disqualified from hearing a matter. As to the nature of the human subject, in the English test, the fair-minded observer excuse me, is an independent person, not a person in the position of the litigant before the judge. Further, the fair-minded English observer appreciates the context of the material before them and reserves judgment until they have fully understood both sides of the argument. In the Australian judicial and non-arbitral test, the fair-minded observer is a layperson who is not unduly sensitive or suspicious and who has an understanding of the relevant circumstances of the case and ordinary judicial practice. The need for this degree of detachment from the special knowledge and expertise of judges and lawyers reflects the constitutional importance of the judicial process as the open and public exercise of state power. As will be seen in Lord Hodges' judgment in Halliburton, the context of the arbitral process perhaps lessens the need for emphasis on public confidence, but heightens the need for emphasis on participant confidence and general confidence in the system of arbitration as part of an international system of justice. The institutional integrity of a court should not be able to be impugned too lightly. At the same time, the challenge should not be so onerous as to permit judges to adjudicate in circumstances where a reasonable human perception would call that into question. The textual expressions of the test in England and Australia reflect the difficulty of this balance. There is a lack of equivocation in the English test. There is a real possibility of bias because the circumstances would lead to the fair-minded and informed observer to that conclusion. The non-arbitral test in Australia may perhaps be seen as more attenuated. The observer might reasonably apprehend that the judge might not bring an impartial or unprejudiced mind to bear. Though not to be viewed in a mathematical way, two mights, even if firmly established as they have to be, seem less stringent and open to more equivocation than one would, leading to a real possibility. All this said, one needs to be careful of over-precise linguistic expression when the proposition involves the implicit, the less than certain, the intuitive, and human feeling, albeit derived from rational thought. The underlying notion is elegantly expressed in the model law. Are there justifiable doubts about independence or impartiality? This is a factual question that is to be examined contextually. The two contexts of public judicial institution, of a public judicial institution, and of a private panel of people partly chosen by the parties are very different. That difference does not necessarily entail the need for a differently framed question, but rather the recognition of a different factual context in which to answer it. So, is the arbitral test in Australia higher than that for Australian judges and other public decision makers? Those advocating for and making the change certainly thought so, as a way of stopping what was seen as increasingly common procedural tactic in high-value international commercial arbitration. The explanatory memorandum to the Commonwealth Act expressly referred to the decision of Lord Goff in Goff as a different and more stringent standard to that derived from the Australian High Court cases. Yet, as Lord Goff himself made clear, the test of danger or likelihood was won by reference to possibility, not probability. Australia's arbitral test is clearly linked to the Queen and Goff. The real question is whether it will be construed as modestly adjusted and explicated in and by Porter and McGill, Hello and the Secretary, and in re medicaments. Debates about refinements of degrees of possibility are likely to be arid and unhelpful. That is why Lord Hodges' judgment, with its emphasis on arbitration context rather than textual comparisons, is very valuable. It is important to recall that the apprehension is one of bias or partiality or prejudgment, not of loss of the adjudication. Litigants often fail to grasp this. The fact that a judge has decided a legal point before is not of itself a ground of objection. The apprehension must be of not being able to bring an open mind to bear on the arguments, not an apprehension that the judge is more likely to follow precedent perceived to be unfavourable. But some kinds of prior decisions can reasonably be seen by the hypothesised human construct to be more difficult to eradicate consciously or subconsciously from even the trained judicial mind. An earlier finding of fraud or dishonesty may be impossible to remove from the mind. Such prejudicial earlier findings raise the issue of unconscious bias. There is a growing body of literature which, drawing on modern psychology, addresses the impact of subconscious forces upon the judicial and arbitral mind. This includes dealing with the operation of confirmation bias and the role of intuitive first perceptions and ordinary human prejudices. The risk of unconscious bias may rise to the level of apparent bias. Related to any formulation of apparent bias is the question of disclosure of matters to parties. Many judges feel more comfortable in approaching the question of disclosure broadly, disclosing matters of connection that may not justify recusal, but they do so to ensure confidence and trust in the parties of the process, given that one party will always lose. It is part of bolstering the institution rather than complying with any legal duty expressed as an incident of judicial power. In Australia, the High Court has said that where a judge is unclear whether he or she should recuse him or herself, disclosure of the circumstances should be made as a matter of prudence and professional practice, saying that it was neither useful nor necessary to describe this practice in terms of rights and duties. The place of disclosure, and for arbitrators, the legal duty attending it, was at the centre of Halliburton. Legislation governing arbitration, model laws and arbitral rules generally express independence and impartiality as core tenets of the arbitral process, variously but similarly dealing with the test for them and with the question of disclosure. It is to be noted that some of the tests relating to disclosure are explicitly directed to what would be thought by the parties. The reference to the perspective of participating party is a distinct feature of these tests as compared with tests for judicial bias, and may be appropriate in the context of arbitrations, where considerations of the exercise of public power and the interest of the public at large are absent, and the confidence of the parties is paramount. The reality of the place of party autonomy in choice and role of the party-appointed arbitrator should be confronted. The different institutional contexts of curial and arbitral adjudication are again important. In the case of a litigant before a court, a judge is allocated to a case because the state has identified a particular judicial resource as suitable. The parties have no choice in the matter. Therefore, a challenge to a judge involves an argument that the state's process of allocation of a judge to be imposed on the parties should be overturned as a matter of law. This is a legal right to demand of the state that a particular person should not remain allocated. In contrast, in arbitration, the question is whether the parties will consent to submit their dispute before a particular person or persons. Disclosure is thus not merely a question of confidence. It goes to the very foundation of whether the parties will choose this person or persons to adjudicate their dispute. The first point of disclosure thus arises at the point of choice of arbitrator. Especially because of the confidentiality of arbitration, matters of importance may not be public knowledge and may therefore suggest disclosure. Thus, there must be some scope for parties to communicate with a prospective appointee in order that the party ascertain the suitability of the person for nomination by the party, and institutional rules reflect this freedom. Although it is generally accepted that the party-appointed arbitrators must be independent and impartial as required by national laws and institutional rules, the requisite degree of impartiality required by a party-appointed arbitrator remains a vexed question in international arbitration. Indeed, the contested role of the party-appointed arbitrator has led some, most notably Jan Paulsen, to call for the abandonment of party-appointed arbitrators altogether. The epicenter of the contemporary debate appears to be whether party-appointed arbitrators do or should play a particular role, sometimes dubbed a special role, in an arbitration, as compared with a neutral presiding arbitrator or chair. For Raymond Bishop and Lucy Reed, a special role arises because of the natural distinction between parties' expectations for the party-appointed arbitrators and the presiding arbitrator. By virtue of being selected by a party and consequently being likely to share similar national, linguistic, cultural and legal backgrounds to that party, a party-appointed arbitrator may be seen to have a particular obligation to understand their appointing party's case, ensure that the presiding arbitrator is not biased against their appointing party, and translate their appointing party's case when language, cultural or legal background may be distorting the other tribunal members' understanding of their claims. Redfern and Hunter describe such functions as useful in ensuring due process for the party that nominated him or her without stepping outside the bounds of independence and impartiality. Bishop and Reed contend that a distinctive role for the party-appointed arbitrator is the prevailing practice in international arbitration. From one perspective, these views are not a denial or qualification of the duty of impartiality. Rather, they reflect how practically that duty should be seen to operate in the real world. It is not partiality for one party, it is ensuring that the party's case is well understood by the whole tribunal. The distinction is subtle, but perhaps real, although the danger of sliding towards partiality can be recognised. Others are opposed to any recognition of a special role for party-appointed arbitrators, on the basis that doing so inevitably introduces confusion as to expected standards of impartiality and independence. Excuse me. The Chief Justice of Singapore wrote in 2017 that he was fundamentally uncomfortable with the suggestion that party-appointed arbitrators owe their appointing party any special duty. Chief Justice Menon stressed that all arbitrators are obliged to consider carefully the cases presented by both sides, and cautioned that the line between driving a lively discussion to ensure a party's case is fully understood and urging that party's position upon the arbitral tribunal may be so fine that it is impossible to work with in practice. Chief Justice Menon's driving concern was the maintenance of confidence in the institution of arbitration. and the perception that it is a procedurally fair process of dispute resolution. It is difficult, however, to avoid the recognition that, as Gary Bourne says, party-appointed arbitrators are an important pillar supporting trust and confidence of commercial parties in international arbitration. As an incident of the centrality of party autonomy in international arbitration, and as a matter of practical reality, the ability of parties to name a person of their choice to the arbitral tribunal engenders an arbitration with legitimacy for them. Such legitimacy may be seen as crucial to the party's investment in the fairness of the process of arbitration and their respect for its outcome, whether favourable to them or not. Excuse me. I now turn to Halliburton. In the interest of time, I will abbreviate the facts. The case concerned a large insurance claim by Halliburton under the Bermuda form, nominating New York law but London ad hoc arbitration with 3 arbitrators, 2 party appointed, and a chair. In connection with the Deepwater Horizon oil spill that you'll all remember in the Gulf of Mexico, Chubb was insurer not only for Halliburton, but also for others, including a company called Transocean. There were multiple arbitrations involving Chubb and Halliburton and others. Mr. Rokerson, a distinguished English silk, after all proper disclosures about past appointments involving Chubb, was appointed by the London High Court as chair of the arbitration over the objection of Halliburton. And that was reference 1. Mr. Rokerson later took an appointment in 2 other arbitrations as a party-appointed arbitrator nominated by Chubb in reference 2 and by other parties in reference 3. There was the potential for overlap in the evidence and issues in those arbitrations with reference 1 involving Halliburton, unless references 2 and 3 were cut short, as indeed, in fact, they were, by a decision on the policy wording. Mr. Rokerson did not disclose these later appointments to Halliburton after he'd been appointed to reference 1. So it's unconscious bias about material he might get in other arbitrations. In November 2016, Halliburton learned of Mr. Rokerson's appointments in references 2 and 3. Halliburton's attorney wrote to him referring to the IBA guidelines on conflicts, which contemplated a continuing duty of disclosure on matters on the orange list. In explanation, which was accepted by Halliburton as truthful, Mr. Rokerson said that it had not occurred to him that he was under a duty to disclose the later appointments, and that he did not believe that the IBA guidelines had been breached. But he said that with the benefit of hindsight, it would have been prudent to inform Halliburton. He apologised. He offered to resign from references 2 and 3 if the preliminary issue did not bring an end to those arbitrations, which in fact it did. Halliburton's lawyer repeated his concerns and called for Mr. Rokerson's resignation. Mr. Justice Popplewell, who heard the matter at first instance, described some of the terms of the attorney's correspondence as grossly offensive. Chubb would not, however, agree to Mr. Rokerson's resignation. Mr. Rokerson again wrote, repeating his views that the IBA guidelines had not been breached, but again accepting that with hindsight it would have been prudent to have made disclosure. He said that he had not learned of any facts about the incident in references 2 and 3 that were not public knowledge. Excuse me. He said that he would resign if it were only up to him, and suggested that the parties agree upon a substitute chair. On the 21st of December 2016, Halliburton sought Mr. Rokeson's removal as arbitrator in the High Court under Section 24 of the 1996 Act. The application was heard by Mr. Justice Popplewell, who dismissed it on the 3rd of February 2017. On 1 March 2017, awards were issued in references 2 and 3, deciding the preliminary issue in favour of Chubb. On 5 December 2017, the tribunal in reference 1, that is the Halliburton reference, issued its final award, deciding in Chubb's favour. The award was signed by all 3 arbitrators, though Professor Park, who was Halliburton's party-appointed arbitrator, qualified his signature with separate observations to confirm his participation, but he expressed an inability to join in the award because of his profound disquiet about the arbitration's fairness. The separate observations did not, however, dissent from any finding of fact, statement of applicable law, or process of reasoning or final conclusion. Interestingly, for the discussion of party-appointed arbitrators, the evidence in the High Court challenge to Mr. Rokeson revealed that Professor Park had been Halliburton's party-appointed arbitrator in 3 references against different insurers in the Deepwater Horizon claims without any formal disclosure. The Halliburton attorney who had confronted Mr. Rokeson in the correspondence described by Mr. Justice Popplewell suggested in evidence that Professor Park was in a different position to a party-appointed arbitrator, to be distinguished from Mr. Rokeson's position as a chair or umpire. The term was used. The use of the term umpire implied an advocacy role for the party-appointed arbitrator beyond any notion of cultural translation. From these facts, the Supreme Court dealt with the questions of disclosure, confidentiality, and apparent bias in, if I may be permitted to say, a thoughtful and sophisticated judgment. Lord Hodge, for the court, with additional insightful comments from Lady Arden, clarified a number of important aspects of English common law in relation to apparent bias and disclosure in the context of arbitration under English law. In summary, the conclusions were 6 as follows. 1, the obligation of impartiality is a core principle, and the duty applies equally to party-appointed arbitrators and the presiding arbitrator or chair. This resolves, for English law, the debate about the role of party-appointed arbitrator, though in the operation of the duty to disclose and of the test of apparent bias, the existence of the debate and differences of views were recognised to be important. 2, the relevant human construct to assess both whether a duty of disclosure arises and whether there is a real possibility of bias is the fair-minded, informed observer, and the test of bias is whether the observer would consider whether there was a real possibility, of bias assessed objectively. This assessment is made having regard to the customs and practices of international arbitration in any particular field. This equates, as Lord Goff had urged in the Queen and Goff, the expression of the test for apparent bias in arbitration with that of curial adjudication. 3, there is a legal duty of disclosure, which is a component of or drawn from the statutory and contractual duty to act fairly and impartially. The duty of disclosure is wider than matters that would give rise to an apprehension of bias and extends to matters that would or might give rise to an apprehension of bias. The duty of disclosure is a continuing one. This can be seen to distinguish the position of arbitrator from that of judge if, as in Australia, the similar disclosure is a matter of prudence and professional practice for a judge. 4, the duty of disclosure does not override the arbitrator's duty of privacy and confidentiality, but absent a contract restricting disclosure, certain matters can be disclosed without breach of the duty of privacy and confidentiality and without obtaining specific or express consent. The identity of the common party in multiple references, whether a proposed appointment to another reference was to be a party appointment or as the nomination as the third arbitrator, a statement of the fact that the other reference arises from the same incident or have the same or overlapping subject matter, and a high-level statement about whether similar issues were likely to arise in the other reference. Consent to such disclosures can be inferred. 5, a failure by the arbitrator to make disclosure, which should have been made, is a factor to be taken into account by the fair-minded and informed observer construct as to whether there is a real possibility of bias. 6, the relevant dates to evaluate whether the duty of disclosure has been complied with or whether there is a real possibility of bias are different. For the former, disclosure, the test is prospective by reference to facts excuse me, and circumstances at the time the duty arose, that is, the duty to disclose. For the latter, that is, whether there was bias, the test is by reference to facts and matters known at the date of the relevant application to the court, such as to remove the arbitrator. Time does not permit a detailed examination of the reasons of Mr. Justice Popplewell or the Court of Appeal. Neither found a basis for apprehended bias, but the Court of Appeal, unlike Mr. Justice Popplewell, said that Mr. Rokerson had failed to comply with a legal duty of disclosure. The appeal to the Supreme Court by Halliburton attracted interventions by the LCIA, the ICC and CIR that the Court of Appeal's judgment was out of step with international standards in their discussion of multiple common appointments. Other interventions were made by the LMAA, Maritime Arbitrators, GAFTA and Arias UK Reinsurance Arbitration Society, which were anxious to see unimpaired the ability to appoint common arbitrators to chain or string supply, transport, shipping and reinsurance arbitrations. Halliburton's case was one of unconscious bias. In Mr. Rokerson taking the benefit of paid appointments in references 2 and 3, he gave Chubb an unfair advantage in being a common party in related arbitrations where, to the ignorance of Halliburton, he could be influenced by evidence and submissions in references 2 and 3, which could affect his approach in reference 1. Chubb would know of his responses to evidence and submissions in references 2 and 3, but Halliburton would not. And the failure to disclose deprived Halliburton of forming its own view about the position. And Mr. Rokerson was said not to have paid proper regard to Halliburton's interest in the fairness of the procedure. The discussion of principle of impartiality. Lord Hodge applied in the arbitral context the relevant test for apparent bias in the judicial proceedings taken from Porter and McGill, Hello, and the Secretary of State. Without going into detailed textual comparison, and if I may say so, rightly so, he said that the English common law test was similar to the test of justifiable doubts in the UNCITRAL model law. This test was held to apply to judges and all arbitrators. However, the importance of the reasons of Lord Hodge can be found in his lordship's emphasis on context and his helpful discussion of the contextual differences between judicial and arbitral adjudication. They were as follows. First, frank disclosure in arbitration is crucial because of the privacy of the consensual arbitration. There may be no public record to which to have regard in evaluating an arbitrator, which makes it difficult or impossible for an arbitrator's participation in multiple references and the submissions and evidence led in them to be known by those not participating in those references. Secondly, there is usually no appeal from an arbitral award, and there are very limited powers of review. Therefore, the choice of arbitrator is of critical importance. Thirdly, the judge holds public office and is paid by the state. The arbitrator is chosen by one or both parties or by an institution and is remunerated by the parties and ultimately by the losing party. An arbitrator in practice has an interest in future appointments. This may give rise to an interest in avoiding action that may alienate the parties, such as assertive case management. Fourthly, there is a diverse range of persons who may be appointed as arbitrators, coming from many jurisdictions and different legal traditions, with potentially diverging views on ethically acceptable conduct. Fifthly, and importantly, Lord Hodge recognised the differing understandings of the obligations of the party-appointed arbitrator. Excuse me. His lordship referred to the lively debate as to the role of party-appointed arbitrators and the literature to which I've referred. Lord Hodge rejected the nuances involved in the debate. No allegiance or duty is owed. No representative role is undertaken. Once appointed, independence and impartiality are unqualified. Lord Hodge was expressly influenced by the place of London in arbitral adjudication and the English legal system's reputation for guaranteeing neutrality and impartiality. His lordship drew from Chief Justice Menon's article that the requirement that all arbitrators had the same undifferentiated duty reflects an increasingly widespread legal norm. Whilst recognising that the view was not universal and that some legal systems do accept that the party-appointed arbitrator has a special role in his or her appointing party, to his or her appointing party, excuse me, this was not so in English law. So, in applying the relevant test, one does not have regard to the characteristics of the party, including whether one or more is foreign. The contrast in approach in different legal systems was illuminated by the discussion by Lord Hodge of the 2018 Second Circuit decision in certain Lloyd's underwriters in Florida, which expressly recognised, as do other United States federal circuits, a distinction between party-appointed arbitrators and neutral arbitrators, and that party-appointed arbitrators were expected to espouse the view of the appointing party and serve as de facto advocates. Lord Hodge then sought to recognise this international divergence in the perception of the role of the party-appointed arbitrator in a subtle and important discussion of the attribution of knowledge to the human construct. The fair-minded and informed observer would be credited with the knowledge that some, perhaps many, parties and arbitrators have the view reflected in the Second Circuit's reasons, and that there is a debate within the arbitration community as to the role of the party-appointed arbitrator and the compatibility of that role with the requirement of impartiality. This was not to recognise a different obligation within the application of the test in England. Rather, it is to understand the context in which the objective judgment by the court through the human construct will be made. The discussion of principle of the duty of disclosure. The Court of Appeal was, in Lord Hodge's view, correct to hold that there is a legal duty to disclose in English law. In arbitration, it arises from the obligation under the 1996 Act to act fairly and impartially, which gives rise to an implied term in the contract for the need to disclose matters. To align or reconcile the duty to disclose with the duty of privacy and confidentiality, it becomes necessary to obtain the consent of relevant parties to disclosure, failing which consent, the offered appointment must be declined. However, the context of particular trades or institutions, such as dealt with by the LMAA and GAFTA and ARIAS, may found an implied consent to multiple appointments. Importantly also, there was the recognition of the entitlement to disclose confidentially the existence of a current or past arbitration involving the common party and the identity of the common party, but not the identity of other parties without obtaining consent from all such parties. Such entitlement comes from common practice. So, at least in Bermuda form arbitration, an arbitrator may, subject to contrary agreement, make disclosure on a confidential basis of the existence of the arbitration and the identity of the common party without the express consent of the other parties. Consent of the common party is inferred. As to the content of the duty, Lord Hodge considered that with one qualification, the duty expressed by the Court of Appeal was correct. Disclosure should be given of facts and circumstances known to the arbitrator which would or might give rise to justifiable doubts as to his impartiality, which means that facts or circumstances which would or might lead the fair-minded and informed observer, having considered the facts, to conclude that there was a real possibility that the arbitrator was biased. The qualification of Lord Hodge was to what was known. Generally, there is no duty to inquire. One must disclose what one knows. However, Lord Hodge would not rule out circumstances raising a duty to make reasonable inquiries, noting that the IBA guidelines, Part 1, General Standard 7D, provide for a duty to make reasonable inquiries. His Lordship left to future cases the development of the question by reference to arbitral practice and rules. Lord Hodge then discussed the phrase would or might. Any obligation to disclose something that might give rise to justifiable doubts can only arise, his Lordship said, where the matter might reasonably give rise to such doubt, might reasonably give rise. Lord Hodge discussed the human contextual reality, the existence of matters that, if unexplained, would give rise to justifiable doubts. So the necessity to disclose and explain, or matters more than trivial, which could by themselves or with other facts give rise to justifiable doubts, if later discovered. This analysis, necessarily less than precise, begins to explain the wider notion of disclosure and its relationship to the test for apparent bias by reference to appropriate human conduct to maintain trust in the particular tribunal members and in the institution and process of arbitration as a whole. As the discussion by Lord Hodge makes clear, The good sense of this approach comes from the consensual character of the process and the central value of party autonomy. It is the party's process. That is the attraction of arbitration. The existence of matters that might reasonably found a justifiable doubt as to impartiality, then or later, calls forth a sense of entitlement in the parties to know of the matter and to consider their position for themselves. Reasonable minds can and often do differ about these sorts of questions. To recognise that and the policy of supporting trust and confidence in a consensual relationship built on party choice and autonomy justifies this wider penumbra of the obligation to disclose. The development of English law to impose this duty was seen to be consistent with developments elsewhere. Whilst the expression of the obligation under English law is not directed, as many arbitral rules are, to the perceptions of the parties, the distinction is unlikely to be sharp in practice. As expressed in summary form by Lord Hodge, it is sufficient if matters are such that they are relevant and material to an assessment of the arbitrator's impartiality and could reasonably lead to such an adverse conclusion. In practice, and in the context of the reality of the parties before the arbitrator, it is difficult to see how the objectively perceived relevance to the parties is not central to the objective assessment by the fair-minded and informed observer. The duty of disclosure is continuing and subject to changing circumstances. Its fulfilment, as I said, is to be tested prospectively and not retrospectively by reference to the matters known later to the fair-minded and informed observer at the point of assessing bias. However, the question of whether justifiable doubts exist is to be expressed by reference to the facts as they exist at the time of the application. Against that detailed discussion, Lord Hodge concluded that Mr. Rokerson should have disclosed to Halliburton the multiple references, but that in all the circumstances, by the time the matter came before the court, the fair-minded observer would not have reached a conclusion of apparent bias. Particular relevant circumstances to that evaluation included that Mr. Rokerson gave an explanation of his failure to disclose his appointments in references 2 and 3, which was accepted by Halliburton as a genuine oversight. Mr. Rokerson was of the view that there was no material overlap between the references and had offered to resign if the separate issues in references 2 and 3 did not dispose of those references. And, not unimportantly, as a lesson to us all, Mr. Rokerson had at all times adopted courteous and measured responses. Well, where does all this leave us? Halliburton highlights with clarity the intimate relationship between the duties of impartiality and of disclosure. Parties are only equipped to make a judgment upon whether they are satisfied that an arbitrator is sufficiently impartial, notwithstanding a potential lack of complete independence, if they are aware of all relevant circumstances, including multiple or overlapping appointments. An explicit duty of disclosure is a necessary incident of the private and confidential nature of most arbitrations, which may prevent the parties from ascertaining a complete picture of the circumstances from their own inquiries alone. In what may be seen as a welcome development supporting the all-important trust of the parties in the arbitral process, the legal obligation to disclose a wider range of matters than those which would found a conclusion of apparent bias can now be taken to be recognised not just in many arbitral institution rules, but also by the common law of England. Commentary on the Supreme Court's decision has canvassed areas for further development of the common law of England with respect to disclosure and remaining issues for debate. That does not reveal any omission in the judgment. Rather, it reflects that decision-making in the context of concrete problems rather than exhaustive rulemaking is the foundation of the common law's support for honest good sense in commerce. Excuse me. The emphasis, with great respect, correctly, placed by Lord Hodge on context may contain the key for those in Australia who may have to determine, as a matter of statutory construction, whether there is really any practical difference, at least in likely result, between the Goff test introduced into Australian arbitration legislation, with or without its modest adjustment in Porter and McGill of a fair-minded and informed observer, and bearing in mind Lord Phillips' view as to the identity of real possibility and real danger, removing any connotation of immediacy of threat from the word danger, and Lord Hodge's view of the similarity of the model law, justifiable doubts, to the English test, and the Australian judicial test, if applied in the context of arbitral adjudication in the relevant field of commerce in which the arbitration takes place, and if firmly established. An issue that is perhaps underexplored in the commentary to date is the impact of the decision on the position of party-appointed arbitrators. I make several final observations in this regard. First, English law has set its face against recognition of any form of special duty or role of a party-appointed arbitrator or of the chair. Excuse me. That said, secondly, there is a recognition of the legitimacy of other views and other approaches about this in other jurisdictions. Thirdly, it is not clear how taking these matters into account as part of the context in the appreciation of the fair-minded and informed observer's task will play out. That perhaps is only an aspect of the intensely factual and contextual nature of the relevant evaluation. Fourthly, the use by Lord Hodge of the Second Circuit decision in Florida, in the Florida case, may not, with respect, fully deal with the subtleties involved. The American position, even after the change to the AAA ABA Code of Ethics in 2004, towards recognition that all arbitrators should abide by the same formal ethical standards, is expressed partly by reference to pre-2004 prevailing authority in the Supreme Court discussed in Florida, in language accepting the place of advocacy on the part of the party-appointed arbitrator. The views of others as to the importance of the party having an impartial but culturally and conceptually aware nominee can be seen as more subtle than the American position. The confidence of parties in the arbitral process is crucial. That confidence is bolstered by an ultimate demand for honesty and impartiality, but it also may be seen to be bolstered by parties being happy with their informed choice of arbitrator to decide their dispute with the other side's appointee and a chair chosen by them or appointed independently. There is already a qualification to independence. The arbitrator is chosen, not imposed. But there need not and should not be a qualification to impartiality unless the parties wish to choose a system and supervising court that finds impartiality to be legitimately qualified by a duty to advocate one side's case. Fifthly, whether one personally agrees with the views of Chief Justice Menon and Jan Paulsen, or with those of Gary Bourne, Raymond Bishop and Lucy Reed, may not matter. different arbitral laws, statutory and general, may express themselves differently, just as the Second Circuit and the Supreme Court did in Florida and Halliburton, respectively. This displays a choice that is given to parties and their advisors about the law of the arbitration and of the seat. Parties can choose the approach they wish to have taken. Sixthly, and finally, the debate about party-appointed arbitrators may underscore the distinction between institutional and ad hoc arbitration. A denial of the right of party appointment would throw into high relief the need for the integrity of the institution appointing the arbitral panel or the pool from which the arbitral panel is to be chosen. Reliance on the institution may simply push the relevant questions of independence, impartiality, and disclosure further away from the knowledge of the parties and from the operation of party autonomy. Or it may give institutions the opportunity to fashion bespoke solutions to any perceived problems of compromise of impartiality by party appointment. Thank you. And I apologise for the residue of my bronchitis, not COVID, that I'm now getting over. Thank you.
James, thank you very much for that fascinating lecture on a very important topic. I appreciate very much that you have been suffering with the fag end of bronchitis. I don't want to prolong the agony.
No.
I'll ask a few questions, and maybe
Sure.
people in the audience would like to ask some questions. I want to take up the main point about the role of the party-appointed arbitrator. I want to ask you a question first. In the American case, Florida, was that a domestic arbitration or an international arbitration?
It was, it may have been a domestic arbitration, I think. I don't have the case with me.
Yes.
And that's certainly, reflective of the quite stark expression by the Second Circuit and the use of the Supreme Court decision under the FAA.
I thought it was a domestic case because the international rules in America don't support that view, do they? I mean,
After 2004, yeah.
So that's one point. On the question of the role of the party-appointed arbitrator, it seems to me that Chief Justice Menon is absolutely right, and I find it hard really to see the contrary argument, because first of all, every arbitrator has the duty to understand the case of both parties. And it's rather unreal to say that the party-appointed arbitrator has to sort of act as a sort of semi-advocate to make sure that the other arbitrators understand the case. He may do a good job and convince them when he himself thinks it's a bad case. And I think Sundaresh Menon is absolutely right that that can't be the duty. And so I want to follow on from that. What do you think about the possibility of blind appointments, so that the arbitrator doesn't know who appointed him, but the parties have chosen him? Yeah. So I want to choose you, and I get the ICC to appoint you as an appointing authority, and you don't know which party you're appointed by.
That should satisfy the most parties, I would have thought, for having their person who they think is suitable act in the group, and that I think will be taken up by, as it already has been, I think, by some institutions as a means of mediating, if you like, the competing notions of purity of the impartiality with a degree of importance placed on parties of having someone they trust.
Well, let me ask you this. As a judge over many years, have you ever accused yourself?
I've done so in not listing myself, yeah, but not on a case, not on a case where I've been challenged. It's interesting, and this is the difficulty with the might test. The vast bulk of the challenges are made by litigants in person. But there are good occasions where apparently good grounds are made. The High Court's just given special leave in a bias case from the federal court, apparent bias, where a judge refused to disqualify himself in hearing a matter where he had acted as DPP against the party in another matter, putting submissions only in the Court of Criminal Appeal.
Well, let me give you, put a specific point to you. Let's assume, I know you have a brilliant associate working with you, and now assume that that associate tomorrow joins a major law firm and they have a case in front of you in 6 months' time. What would you do?
I wouldn't even disclose it.
Now, would it be any different if you were an arbitrator? Because this does come up quite a lot. And what happens if somebody was my legal assistant 20 years ago? Surely I didn't disclose that. No. But 6 months ago or a year ago, maybe you should.
Certainly there would be a question if you knew that the legal assistant had acted in this matter or a similar matter for you in work on the court. And that sometimes arises in the reverse way. I've had to borrow an associate and hand the associate to the judge from whom I've borrowed the associate for a particular case, where the associate has been actually working on the case in the law firm before coming to me.
Yeah. Let me just ask you a bit about unconscious bias. I mean, it's unconscious, so we probably don't know too much about it, but we are aware of it as a feature. Do you think there's anything we can do to make ourselves more aware of it as judges?
I think read some of the literature, which I found fascinating in preparing this, and I've left it in a footnote.
Yes.
Yeah, and reading Kahneman's books on thinking fast and slow, and the importance of the leap, the instinctive, intuitive leap into the thought process, and in something I've also written about in the last couple of years, the place of that intuitive leap and the place of metaphor in how you solve a problem, which is very much a part of the instinctive creative thought process of using parallel metaphor, parallel ideas to give content and illumination to a problem. One of the problems with metaphor and intuitive structure is that it can answer the question before you've even thought about it. My best example is the Gene Patton case, which were overturned, so I can't say too much. But in my view, the metaphor that was ultimately used in that case and that's what we said in the Court of Appeal, was the substitute for analysis of the facts and the legal principles, scientific principles.
Yeah. So we can make ourselves aware that there are these unconscious biases, and there are certain steps you can take to try and counteract them, which I think is set out in a checklist by Edna Sussman, which is quite worthwhile reading for all arbitrators.
Yeah,
I don't know how successful that will be, but
in a sense to modestly recognise one's humanity and one's failing, natural failings. We've all got prejudices, and it's something, and it's a reason, and most persuasive reason, I think, for the greater diversity and of the arbitral profession, as it were, because one finds it with one's colleagues that group thinking tends to result in less than happy results sometimes.
Yes. So one last point. Have you ever, what do you do when a case comes before you where there's a succinct, distinct legal point which you decided before, maybe more than once before, and it's the same point? And do you just say, well, it may be argued differently this time, I have to listen to it?
Well, that's the point I referred to earlier. It's not an apprehension of losing. It's an apprehension of bringing an open and fair mind to bear. If the point is contestable, the point is often raised in putting together a 5-judge bench where there's a re-examination sort of a previous 3-judge bench. I take the view that there's no reason why one or some members, a member or some members of that 3-judge bench can't sit on the 5-judge bench. You don't have to have no one who has ever everyone has to be fresh, because it's not an apprehension of loss. It's an apprehension that people will not bring a legitimately open mind to bear on the arguments for re-evaluation of error. And judges have often been heard to say, that's how it struck me then, but it perhaps doesn't strike me thus today, when their own previous decisions are being used in an argument that they don't particularly like some years later. So it's, I think that, and litigants in person especially just don't get it, and they just want to go. We've got a couple of litigants in person who've gone through over 20 or 30 judges in a 50-judge court, in the sense that they want other judges, and to a degree, there's a tendency to pander to it.
Yeah. Do you think your answer will be any different if you were an arbitrator?
On the question of bias, yes. What's interesting in arbitration is the question of disclosure in that regard. And I think if there were known to be in the arbitral community a split about how some BIMCO form was to be construed, and there was no High Court decision on it from London, from the Commercial Court or the Admiralty Court, I'm not sure whether disclosure that may come out, because LMAA references are published and anonymised, but
yeah,
that's an interesting question, I think. Whereas if as a judge, all your decisions are made public and people can understand what your view is about that point.
Okay, thank you. So before I hand over to Christopher Toe, has anyone in the audience got any questions for the judge? Yes. Excellent. A microphone, please.
Hello, Chief Justice. Can you hear me okay?
Yes, I can. Just.
Okay, great. Great. My name is Jonathan. Thank you so much for speaking to the City University of Hong Kong and taking time out to do that. I have two quick questions because we're short on time. So your quick thoughts on this would be great. One is that at any given time, there's over 200 students at City University learning arbitration, Masters of Arbitration students. What are your recommendations or thoughts to them in terms of going into 2023? Just the general environment and just, you know, ideas that you have that students may want to think about as they move forward in their careers. And second quick question is one of the beautiful things about Hong Kong and Singapore is that they both allow non-lawyers to practice arbitration, both in terms of representing parties in arbitration and also being arbitrators. Well, he might be one of your colleagues, but from the time that you taught at University of Sydney, Luke Nottage has actually written papers on how since the 1990s, lawyers have basically done a wholesale takeover of arbitration sector, and non-lawyers have kind of been pushed out. You spoke about diversity in arbitration. I was wondering if you could give some thoughts on the second question about non-lawyers in arbitration and what can be done to encourage non-lawyers to practice arbitration. Thank you.
Thank you. I'm not sure the answer to the first question. There's what will happen in 2023 and following?
Yeah, just your general thoughts, you know, just your general thoughts and recommendations to students in arbitration and what they might want to think about and consider in the coming years.
I think keeping abreast of as best one can of the literature and the rich discussion of what is, I think, a fascinating development in the last 40 or 50 years of the underpinning of a lex mercatoria, and to keep reading about it. As to the question of non-lawyer arbitration, it's interesting. We have where this occurs in Australia is not so much in arbitrations in building and construction with quantity surveyors, architects and builders and the like, but also in the use of courts in Australia, which is quite active, of the use of referees in disputes, where the task is very similar, with the exception that it's not determinative, it's providing a report for adoption by the court under principles which mean the review of factual questions by a referee will only be undertaken where there's a clarity of error that's quite different from appeals. And what the courts quite often sometimes do now is to use non-lawyer referees, and to the extent that those non-lawyer referees find it of assistance, to give them assistance in the drawing of their final report by consulting counsel. If the non-lawyer is desirous of having some assistance in expressing in terms of structure of a complex case how the report should be expressed. So I think certainly in three-person arbitrations, I would have thought in technical areas there's every good reason to have consideration of non-lawyers.
Thank you very much, Chief Justice Neil Kaplan. Thank you very much, Chief Justice, for that kind remarks in terms of, for example, this area. And on behalf of the City University, our Professor Lin, the Dean, as well as everyone here, and also those online, we thank you very much. I know that you're not feeling too well, and we thank you for actually taking time and an effort to actually give us your talk and your thoughts in this area. So we look forward to actually working with you in the future for the benefit, not just arbitration in Hong Kong, but in maybe the whole world, including Southeast Asia, Australia, and so forth. So on this note, thank you very much. It was a pleasure actually hearing you talk today. And also Neil Kaplan, thank you very much. On behalf of the law school, we thank you for your moderating. On this note, can we invite, for example, Howard Chan? Before I invite Howard Chan, he's a partner and founder partners because they are one of the sponsors of this. And also would like to thank HKIC. He also is a sponsor of the venue here. So can I invite Howard Chan to come and say a few words, please?
Oh, thank you so much, everyone. My name is Howard. Thank you for the introduction. Just a few quick words on behalf of Founder Partners. Welcome to all of you. Special thanks to Chief Justice Alsop, Mr. Kaplan, City U School of Law, and to HKIC for hosting. It is a pleasure to be a reception sponsor or for tonight. It is my pleasure to see such a good turnout of physical attendees this evening, in addition to the 50-odd attendees virtually for this event. This is an extremely good sign, I think. Last month, I was delivering a lecture at the University of Hong Kong. There were less than 10 physical attendees versus a fairly large number of virtual attendees. Now, a few further words. This year marks the 10th anniversary of Founder Partners' presence in Hong Kong, and over these years, we've been proud to have contributed to academic excellence, not just in Hong Kong, but also overseas. Our sponsoring of this reception tonight is, of course, but a small token. While some of our partners in not just our Hong Kong office, but also in the mainland, have been involved in academia in various respects. And we look to continue this for years to come, as well as to contribute generally to the dispute resolution practice, including arbitration and court litigation, which have been and remains our core practice areas over the years. Before I sign off, can I clarify from HKIC staff what time our drinks event will last until, noting the time now is 8 p.m. Do we have 1 hour? Until 1 hour. So we have 1 hour to socialize. That's very good to hear. So without further ado, please enjoy the reception and this evening. Thank you so much.